Case number 116968, State of Kansas v. Shelbert L. Smith.
Mr. Chief Justice, may it please the court, Richard Ney, appearing on behalf of the appellant in this case, Shelbert Smith. Mr. Chief Justice, I would request 3 minutes to be reserved for a rebuttal.
3 minutes is granted.
Thank you, Your Honor. This case comes from Shelbert Smith pleading no contest to murder, aggravated kidnapping, aggravated robbery in the death of a pizza delivery driver. Shelbert Smith was 16 years old at the time. He received consecutive life sentences and another consecutive 10 years to life for the robbery. His attorney failed to file a notice of appeal in this case. 20 years later, the defendant filed a pro se notice of appeal. In August 2014, the district court denied the defendant's right to appeal based on the length of time between the sentencing and a notice to appeal. In 2016, this court found that just the length of delay was not dispositive of the issue of whether the case could be appealed. The court sent this case back to the district court for a hearing on whether Mr. Smith would have appealed and whether he had told his attorney to execute that appeal. In December 2016, a hearing was held. The defendant was again denied his right to appeal, and we come here today. We submit, Your Honors, that the district court failed in understanding and erred in concluding the third Ortiz exception in this case was not in place. The court ruled that the defendant's testimony was not credible, although there was nothing that refuted it. Apparently the court ruled that the grandmother's testimony, also unrefuted, was not credible.
But there was no finding to that effect, was there? The district court didn't make a finding about grandmother, just didn't mention grandmother, right?
That's correct. But we would submit that the court finding...
Which
yes, ma'am.
gets me to what kind of standard we have. Are we looking at substantial competent evidence to support, or are we finding a negative finding? Because that might be a disregard of testimony under the negative finding, but how would that fit into the substantial competent evidence determination? Or you understand what I'm asking?
I think I do, Your Honor. Certainly the court is given the chance to make rulings of fact. But we cited the Denton case. Now, I understand it's an unpublished Court of Appeals case, but it is so like this case to be almost identical. In that case, the court said, well, there's no evidence to the contrary, but I just don't believe the defendant when he said he asked his attorney to appeal. And the Court of Appeals said, no, you can't make that sort of negative finding. So we would say both issues that are at play, Your Honor, that the court has to have at least a basis, an evidentiary basis. Instead, the court based its ruling, we submit, not on substantial evidence, but on speculation and making assumptions about the defendant, who was 16 years old at the time.
A little bit of the reason we don't make credibility assessments is because we have a cold record and we can't look face to face. I'm reading the district judge as assessing body language and affect, and that when he determined that he's a very cold person and that he factored that in. So what do we do with that? Because we've got the problem where we say over and over and over again, we don't assess credibility because we weren't there. And now we have a judge that was there that made the credibility assessment. Yeah.
Well, I understand, Your Honor, but we have to look at this case in the framework of when it happened. This is back in what we used to call the callback era. And callbacks were a specifically strange animal that you didn't appeal 10 days or 14 days after the sentence. You waited, well, whenever. Sometime after the hearing on the motion to modify. So we have a record here of the judge telling the defendant, look, you really aren't being sentenced finally today. We're going to bring you back here, and we're going to do this, and we're going to do that, and then the sentence will be final. So how is he to proceed? As Mr. Smith said, I told my lawyer I wanted to appeal. But when I tried to reach him, when I had my grandmother call him, and she testified 5 to 10 times, I couldn't get a hold of him.
Well, the first time,
Yeah.
I understand the facts are, the first time that he told Mr. Opperman to appeal, Mr. Opperman says, no, it's too early. You wait for your call back. You might get probation. It might change what we asked for. And that's the most credible thing that I've read in here, is because that was what was done. If you were appointed to represent someone, you waited till the callback and you got your diagnostic center reports and all of that. You had some ammunition to go to the court for modification.
Right.
So the ignoring was after the diagnostic center report came back and the motion to modify was filed.
I understand that. But let's look at the two sides of this. Because the court, in fact, commented on Mr. Opperman's practice here in this case. And let's be clear. He waived the map of this 16-year-old. He waived the preliminary hearing of the 16-year-old. He pled him no contest to 2 counts of murder and a count of aggravated robbery, just basically the whole case. There was no real concessions here at all by the state. And he got sentenced to maximum consecutive sentences. He does not, and by the way, he made 5-sentence argument at the sentencing hearing before the judge. So this is an attorney, who doesn't deserve a lot of credibility in the sense that, oh, well, Mr. Opperman was very careful, and he certainly would have done an appeal in this case if you had asked. I don't think Mr. Opperman, deserves that credibility. In fact, the judge said in the record, I am amazed by the representation that was provided back in 1994. Apparently he just went along with getting MAP, pled no deal to short of a death sentence, the worst sentence that could have been imposed, and did not file an appeal. So I get what you're saying. That's the district court's statement during the hearing. So then we have my client who has said, I want an appeal, but the court is saying, oh, well, I don't believe that. I believe he got a life sentence, 2 consecutive life sentences, and really didn't care about appealing.
Could you back up a little bit procedurally what happened back in 1993? My understanding is that he was sent to SRDC for his evaluation, those of us that remember
Yes.
those, and then the motion to modify was never heard. Or is it just silent? What happened there? Because that to me is important as to whether even counsel and your client ever met after the original sentencing.
Well, it's
What
clear.
happened?
Yeah, it's clear there was no hearing. That's number one. My client was not brought back, as was the usual case.
Right. That was pretty standard.
Yeah, I'm old enough to testify.
Right.
That's how it happened. There was no hearing that we could determine in the sense of people gathering and a
Right.
record being taken.
Right.
There was no journal entry whatsoever on the hearing. Is there a ruling? We don't know.
There's something in the record that says it was denied.
Yes. So a minute entry, if you will. That's basically it.
But no journal entry.
I'm sorry?
No journal entry.
No journal entry. Which frankly raises the question whether, and again, I understand what this court sent back was on the third Ortiz exception. But there's a question whether his appeal time has started running at all.
Right.
Because under the case law at the time, as we cited in our brief, until the journal entry was filed, the appeal time did not run. So again, that's another question that's out there.
So there's nothing evidenced in the record where Mr. Smith and his attorney met physically in court after that original sentence?
Not at all. And in fact, to go on with the issue of the attorney, there was a restitution order filed, as we pointed out, and the district attorney's office attempted to reach Mr. Ackerman numerous times to come either agree to or sign off on the restitution order, and it was noted in the record he didn't respond, so they just filed it. So there's clearly nothing happening for Mr. Ackerman past the sentencing date. Usually a motion actually would be filed in that regard. And then we have the issue that my client, 16, basically illiterate, ADHD, taking Ritalin at the time of his arrest. And the court, in the end, says, well, you know what, Mr. Ney, your client could have scrawled his name on a piece of paper, said appeal, and that would have been enough. Well, one, I don't think that's the law under Ortiz, that you, no matter even if you have a PhD, that you have to file a pro se notice of appeal or you're out of time. But secondly, that it required of an individual, a 16, maybe had turned 17 individual, like Mr. Smith, has no factual basis either, that he was competent to do that. When Mr. Smith made his claim to request to Mr. Ackerman that I want an appeal, Mr. Ackerman said, well, it's not time yet. Are we really saying that in the callback era, that a second request had to be made even? But we know from Mrs. Alexander, my client's grandmother, my client's mother is deceased and could not testify, but client testified he had contacted her and tried her to get to Mr. Ackerman, that he had tried to call Mr. Ackerman. But my client's grandmother tried to get hold of Mr. Ackerman 5 to 10 times. Now, what's the purpose of that? You know, she didn't testify that she knew the purpose, but she was trying to get a hold of him to get with the client. And the only reason that could be was because of the appeal. There was really nothing else on the table at that time for Mr. Ackerman. And if we look, finally, under the Ortiz exception, there would have been almost an assuredly granting of the appeal, because there was no journal entry and there was no hearing. A hearing was required under the law, as we pointed out in our brief. And so my client would have gotten a new sentence. And in fact, I'm old enough to remember that you could do 2 notices or 2 callbacks. If you did a callback and it was unsuccessful and you did an appeal, you had a right to do another callback. So what was being flushed away basically by not filing a notice of appeal was almost a sure win, because there had been no hearing. He would have at least got the callback hearing, and secondly, he would have gotten a second hearing, even beyond that. We think that this, Your Honors, that the record here argues that my client would not have sat in prison with 2 consecutive life sentences, that he asked his lawyer to appeal this, and that the record should be that he is believable, and the fact that the attorney didn't appeal it is not much surprise, considering the record of what the attorney did or didn't do in this case. Thank you.
We have any more questions? Thank you, counsel.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. It is the state's position that there is substantial competent evidence here to support the district court's determination regarding defendant's credibility and the Ortiz exception that this was sent back for. If I could remind the court, this was remanded for the express purpose of determining whether defendant's testimony is credible, i.e. whether he told his attorney to appeal, whether the attorney did not file an appeal, and whether Smith would have appealed if his attorney had not failed to perform.
Counsel, can you explain to me why the district court cared about the defendant's tattoos and his music preferences?
I don't know why he cared. I'm
You
sure.
think it would have been better for this guy if he would have listened to Merle Haggard instead of whatever he was listening to?
I don't recall that specific statement about his music preferences, but
There was a reference. The district court. I'm trying to. This goes to the passion prejudice
Right.
part of it, and I'm trying to balance off this young defendant basically giving up on what amounts to the rest of your life in prison sort of choice. And so how does it make any sense that the judge wanted to talk about this guy's tattoos and his music preferences?
I believe what the judge did here is looked at everything before him. Obviously, as this court knows, we don't have the defense attorney. He is deceased. So we couldn't bring the defense attorney to testify. Otherwise, maybe we wouldn't be here. I don't know. But the court looked at everything, the totality in the record, not just...
Counselor, the question is, in the totality, you look at relevant evidence. You don't look at what day of the week it is or what color shirt defense counsel has on. You look at relevant evidence, and the question is, when the district judge ordered the Department of Corrections to provide the tattoos and brands and included a comprehensive list and a photograph of those, what did those have to do with the 3 items that was on the mandate to the district court? And that was, did he request, did the attorney appeal, and if not, would the defendant have proceeded with an appeal if the defense attorney would have done? Those 3 things specifically, and when the judge pointed out the difference between IE and EG, and this was IE, these 3 specific things. What does the tattoos that he has now in prison have to do with those 3 findings and the credibility with respect to those 3 findings?
I recall seeing those requests by the court in the record. I do not recall, though, when he made his ultimate ruling and finding in the case that he spoke regarding the tattoos. The record would bear that out. Yes, the court should take into consideration relevant evidence, but I believe the state believes in this situation, if the tattoos aren't relevant, that's a small piece, I believe, of what the court considered in this case. And I don't recall in the ruling that he spoke to tattoos being a deciding factor in whether defendant was credible or not.
Counsel, excuse me, go ahead. You began with the statement that there was substantial competent evidence. Could you just recite what that substantial competent evidence is, in your view?
Well, I believe in this case, there's nothing here that shows that the defendant was a guy that would fight this appeal despite or but for counsel filing a notice. We have the fact that he confessed to planning and carrying out the kidnapping, robbery, and murder of a pizza delivery man. He entered a plea. He claims to be semi-literate and slow. He claimed at the first evidentiary hearing in this proceeding, before it was remanded back, he claimed that he called his attorney 2 to 3 times a day for a year.
I'm sorry, I'm not following how the fact that he claimed he was slow and illiterate and he claimed that he called 2 or 3 times a day supports the judge's ruling. Wouldn't those claims...
I'm getting to that.
Okay.
Sorry. The defendant has to show, and going to Gill, which was cited by this court in the remand opinion, in that case, there was an 8-year delay in that case, and the court indicated that defendant had not shown a manifest desire to obtain relief for his sentence. Similarly, all of these facts that I was going through, in addition to the fact that he claimed his attorney told him that he didn't see him going to prison, the fact that he did let this matter rest for 18 years, he stopped attempting to contact his attorney after 94, he never wrote any letters. For 18 years, he claimed to be accumulating legal stuff. And the fact that he stated it took 17 years to find someone to help him. The court can look at all of that. When I talk about substantial competent evidence, all of those factors, all of that evidence indicates that defendant did not manifest a desire or did not pursue his appeal, despite the fact that his attorney did nothing, which is one of the determinations.
In answer to your opposing counsel's argument, there is a requirement that a defendant make more than one request? Because there isn't any dispute, is there, that he made the original request?
I have nothing to dispute that he made the original
Okay, so that really
request.
takes care of, doesn't that as a matter of law take care of line one? I mean, we had 3 things we asked for the court to address. And the first was whether he wanted an appeal. And he expressed a desire for appeal on day 1. You don't have any evidence to dispute that, right?
Correct. I believe, however, I think the credibility determination from the district court can be looked at regarding that first point
But all
as
of
well.
that evidence you just listed for me has nothing to do with what occurred between counsel and defendant on the day that he was sentenced, right? Which is the day he says, I asked for an appeal.
The day he was sentenced, yes.
Okay, so that's number 1. Number 2, there's no dispute.
True. There's nothing in the
So
record.
really all we're left with is number 3, whether he would have pursued an appeal.
Yes, and I believe our strongest argument does go to that third point. And it is the defendant's burden to show that but for counsel's failure, he would have pursued an appeal. And during this 18-year delay, which I believe we cannot ignore, defendant did not do anything to pursue an appeal. He testified during those 18 years, he told us what he was doing, and he was accumulating stuff, accumulating legal stuff. He never filed motions. He never, even in Gill, I believe that defendant filed motions, but never appealed, never notice of appeal, never speaking to appeal, more about 1507, things like this. This defendant here never filed anything for 18 years, never did anything to indicate he was pursuing this appeal. Instead, he was accumulating stuff. So it's our position that defendant has not met the burden on that third question to show that he would have pursued a direct appeal of his sentence but for the attorney's failure.
On that third question, are we dealing with a negative finding?
Can you elaborate? A negative finding because only defendant testified?
Or that, just in general, that the court found that the defendant didn't meet the burden?
I would think that yes, the court found that he did not meet the burden.
So do you believe we can look at the passion and prejudice analysis of the court? And if so, explain to me how we deal with a district court judge reaching outside the record to gather evidence on his own?
I would go back to my original response regarding. I'm guessing you're speaking about the tattoos.
Yeah, asking the Department of Corrections to provide him with information.
Right. Which, to be honest, I didn't spend much time on because I didn't see it as being a large issue in this case because, again, I don't recall that the district court made a focus.
Let me refresh your recollection.
Thank
on
you.
that. The district judge says there's one of 2 alternatives here. One of 2 things happened here. I'm quoting the judge. One was that this was a young man who, for whatever reason, decided he wanted to go do the rest of his life in prison because he was tough, and that was what he was going to do because that's what people did in the music that he was listening to. So that's alternative one.
I do recall that.
Alternative two is he did exactly what he said he did and told his attorney he wanted to appeal. Now, those are the two options the district court used. It picked one, and it picked it because of the music. That's why it's relevant. And as near as I can tell, you don't have any justification, as Justice Lukert said, of looking outside the record, trying to figure out what kind of music this guy listened to, and then reaching a conclusion about that when there's only one of two alternatives available. Is that where we're at?
It's still the state's position, even though the court mentioned the music he was listening to.
He said because of this, not he just. We all know how to read how judges justify their orders, and he didn't say here's a whole list of stuff going on here. He said because of the music he listened to, he wanted to be a tough guy and spend the rest of his life in jail when he's 19 years old, or he did everything he said he did, and he told his attorney to appeal. Those are the two alternatives. I just think we can't get off of that, and I'm trying to give you a chance to get us off of that.
Well, obviously, I have nothing to go back for and attack what the judge said. I mean, the judge said what he said. There is nothing. Did the defendant testify about the music he listened to? No. So clearly, this is an assumption made by the judge. But I also would state it's still the state's position that there is this delay that we cannot ignore. And while the judge said because of the music, I believe the judge said a lot. His ruling, and look at the record, the judge gave a lengthy ruling. The judge also reduced that ruling to writing. I think it's a 3 or 4 page ruling. And I don't recall anything in that ruling speaking in the written recitation anything about music.
He talks about how cold he is, which is
How cold he is.
How cold he is.
And I believe that might come from the sentencing transcript. I think there was something.
He says that was reflected there, and then he observed it in court himself.
Yes.
I have another question. What do we do at this stage of the game with the fact that there's no journal entry on the motion to modify? Is this a late appeal?
Or even a hearing. No evidence of a hearing.
I would agree that there's nothing in the record as far as transcripts from a hearing, but there is a minute sheet. No, there is not a journal entry, to my knowledge, a traditional journal entry that we are used to lining out what happened at a hearing, but there is a minute sheet indicating that a hearing occurred, and I don't think we can ignore that. So I would not agree with the defense's position that there was no hearing. Also, Opperman, prior to that callback, he did file a motion. I think defense counsel said he's done nothing. He did file a motion asking for a modification to probation, if I recall. So it's the state's position that there was some sort of hearing. But it's based on that minute sheet. And I don't know that we can speculate as to what defendant would have raised in an appeal to determine, to make that determination that he did in fact want to appeal. I think we need to look, as the district court did, at all the evidence, including the delay before it, that shows that defendant did not manifest a desire for 18 years to in fact appeal his sentence.
With the minute entry, is there any indication that the defendant was present?
I don't recall, but I don't think so.
And so can we call that a hearing as required under the law at that time?
I think we could, because I as counsel, I will admit I was not practicing in 1993 during the callback, but as counsel stated, it was not, they didn't bring everybody back for those callbacks. So I think even if he wasn't there, there could have been a hearing.
They didn't, but this judge would, as I recall, made a specific statement to the defendant that your sentence is not yet final, which was a little unusual. I mean, yes, it's correct in a way, but it's not usually the way you would refer to a defendant. It almost indicates the expectation that this defendant would be being returned to for another hearing, which I just think that this is a circumstance that probably would have caused a 17-year-old person to not really understand what the next steps were going to be, just based on the way the judge phrased the statements in the hearing.
I think that's possible, but at the same time, we do have the defendant's testimony that he told his attorney he wanted to appeal, and the attorney told him, not now, we will have that call back. And after that is would be in this situation the proper time to seek an appeal, and so wait. So I don't think we could speculate or guess that he didn't know what was going on because of the court's verbiage at sentencing.
I have one more question. You'd agree that the findings at least the written findings by the trial court did not indicate a credibility judgment on the grandmother's testimony, right?
I think that is, I think that's true. I don't think he spoke to the grandmother's testimony, and I don't see that that's a problem here. I think he had plenty to look at in the record to make a determination that defendant was not credible based on the circumstantial evidence here and the delay that I believe is a big factor. Even this court indicated in the remand opinion that defendant's dilatory conduct might be relevant to the credibility of his claim that he would have proceeded with an appeal if his attorney had not failed him. So I'm out of time.
Counsel, on that last issue of whether the judge made any kind of a credibility determination about grandmother or anybody besides the defendant, I'm looking at paragraph 21 of the judge's journal entry, which you may recall says, independent of Mr. Smith's statements and testimony, the court also finds it incredible that if Mr. Smith had wanted an appeal filed, he would not have been successful in arranging this through his mother, grandmother, or other family member or friend. Is that any kind of a addressing the grandmother's credibility?
I don't know that that would speak to the grandmother's credibility, but I think it speaks to the defendant's credibility that we know from his testimony and grandmother's testimony that he had communication with grandmother, asking her to make phone calls for him. So at the same time, he could have also asked her to file something on his behalf. I think that might be where the judge was going with that, but I don't.
But as a pro se, I think, isn't the testimony that, from her at least, that he wanted her to get in touch with the lawyer and get the lawyer to contact him? That's the extent of it.
That's
right?
the extent of her
That's
testimony.
all we know.
Yes.
Bottom line, no one asked grandmother at the hearing any more than that. And that's what she said.
Correct, and
So what is
she
the
said she
substantial
didn't
competent
know.
evidence to support the finding that my colleague just read? What's the substantial competent evidence to support that if the only testimony was from grandmother that she tried repeatedly and could never get a call back? And that's grandmother, not him.
Right. I think it's the fact that anybody would have the ability. The fact that we know that he was in contact with grandmother.
But
and
grandmother was unsuccessful despite numerous attempts, according to her testimony. That's the only testimony on that point, right? Mother's not there to testify.
True.
So even if we disbelieve him, grandmother testifies. I think we just agreed that there's nothing in the findings that speaks directly to her credibility. But there is a finding that says he could have filed through someone else. He could have filed through mother, grandmother, or someone else. But the only testimony that the judge heard was from grandmother, who said, I tried numerous times to contact the attorney and couldn't get a call back. So how is there substantial competent evidence to support paragraph 21?
I think it's the fact that the court looking at his abilities, that he could have contacted grandmother, that there's evidence that he did in fact contact grandmother and could have asked her to file something on his behalf.
So you're talking about a pro se filing.
Yes, I mean,
So that's not
happens.
speculation on the judge's part. The grandmother would have the tools necessary, the expertise, the know-how to file a notice of appeal as a layperson? That's what you think he's saying there?
It would be my argument that it doesn't necessarily take expertise. I mean, to file such an item.
Okay.
Counselor, your office has on a number of occasions before us argued that the notice of appeal didn't cover the particular item that's in the brief before us because it didn't meet the requirements of a notice of appeal. So I don't understand how you can say a layperson would be aware of the nuances of what's required in a notice of appeal. You would agree that your office has challenged notices of appeal in the past, have you not?
I would agree with that. I also think those were situations that were filed by attorneys. Now, I don't know all of them, but I think the majority of those are notices filed by counsel and not necessarily, not pro se
Right.
notices.
I think his point is experts mess up.
It's true. Experts mess up.
So having the underpinning of that finding be that a layperson should be able to do it successfully seems a bit far-fetched. I think that's his point. You appreciate that, surely.
I appreciate that. At the same time, we do have the understanding that for defendants, an ignorance of the law it is not a defense or not an excuse here.
Can a
And-
represented party file his own pro se notice of appeal and have that be the notice of appeal that controls a case? Don't we have law on hybrid representation?
We do have law.
Of clients with appointed counsel? Aren't they generally discouraged from filing their own pleadings when they're represented by counsel?
They are, but that does not, as this court knows, that does not stop that. And I would, during these 18 years, was he represented? I mean, he could have filed a pro se notice of appeal.
Is there
I don't
any
be-
evidence in the record of a termination of the representation?
Well, at least when Opperman died, I believe that would be a termination of the representation, but I don't believe we have
Was Mr.
anything.
Smith aware of his death? Is there anything
I
in the record
cannot
to
speak
tell
to
us
that, I don't know.
Okay, thank you.
Counsel, I just have a quick follow-up to that exchange. Setting aside kind of the credibility aspects of what the defendant did, pro se, or didn't do, why is any of that even relevant to the third Ortiz factor? And what I'm getting at is the district court seemed to consider, well, he didn't file a pro se notice. He should have been able to get family to do this, etc. And that all seems to me to miss the mark of the legal standard of what the third Ortiz factor is, which is if his attorney had not failed. And we're not asking, well, I guess my question to you is, what are we asking? It seems to me that that third Ortiz factor is not asking what would he have done or what should he have done when his attorney failed. It's if his attorney had not failed, would he have pursued the appeal?
I guess I haven't thought about it that way. I think I've thought about it the first way, that if
And I'm suggesting, why is that the right way to think about it?
I believe that's the way it has been set out. I mean, if I'm incorrect, then, but I believe that we have to look at whether, and it's his burden to show that he did something, or he manifested a desire to pursue an appeal. And we have this substantial delay that I don't think can be ignored, and was not ignored by the district court. That's highly relevant here to show that he would not have.
So a
pursued
defendant
an
not
appeal.
only has to demonstrate that they would have pursued an appeal had they had appropriate counsel, they also have to demonstrate that even in the failure of counsel, that they took affirmative further steps. I mean, that seems to me to be adding almost a fourth Ortiz factor almost. And that gets to the relevance question. Why is what he did or didn't do after the failure of his attorney
I think
even relevant? Why is it relevant?
I think it's very relevant. I mean, as I stated earlier, there's nothing, it's the position of the state, there's nothing in this case that shows that this is a defendant that would have fought this. He entered a plea, he confessed, he entered a plea.
And
So-
what was that plea? That plea was nolo contendere.
It was no
Nolo
contest.
contendere says, I don't admit to doing anything, but I'm not gonna fight you. And so why, I mean, the fact that he went nolo indicates that he wasn't given up, and the appeal request was after he was sentenced and given consecutive sentencing, which was pretty draconian on the sentence. And at that point, regardless of plea, he had the right to challenge his sentence, didn't he?
Yes, he had the right
And
to
so
challenge.
the thing is why wouldn't, what is in there would make us disbelieve that he didn't want to challenge that extremely long sentence at that point? After he's told his contemporaneous with the sentence, he says, I want to appeal. And so at that point, as my colleague says, if he wanted to appeal his sentence at that point, isn't that all it takes for the third factor?
I would say not in this situation, not in a situation where you have such a substantial delay. And I would point back to this court's opinion in Gill, and that was just an 8-year delay that the court looked at. And yes, the court said it wasn't a bright line rule, but I think it does need to be considered. And that's the state's position, that this delay cannot be ignored. We have statutes of limitations, we have bars in cases so that there is a finality in a conviction. And so it's our position that we could not, this delay cannot be ignored here. I see that I'm well out of time.
Counsel, just one more question. If we, hypothetically, if the court disagrees with whether that we said we don't see substantial evidence to support the district court's finding, what would the remedy be from your perspective? What would happen to this case?
I believe he would get an appeal of his sentencing.
Okay, well that's one option. Another I can conceive of is, would it require another remand for another? I mean, I guess I'm struggling with still whether or not, if we find the substantial evidence doesn't support the district court's findings, does that necessarily mean that he's met the Ortiz factors?
If you find that there's not substantial evidence to support the district court's ruling, then I could see it remanded for another evidentiary hearing. If you find that the evidence doesn't support the court's ruling, I could see that happening. But of course, as I argued, that's not our position.
That would be the third hearing on this issue in the district court. Is that right?
That would be the third, yes.
Any more questions? Thank you, counsel.
Thank you.
May it please the court. I guess I'm not seeing what the delay is. Before my client ever went to prison, and the state has conceded, he asked his attorney to appeal. They said that happened. All right, I think we're done. He asked his attorney to appeal. Now, he didn't, was it just too early? Is that what we're going to say, that it doesn't count because it was too early? That can't be the law. They haven't contested that happened, so I guess we have to say the defendant had to ask at a particular time. Well, he was never brought back. There was really no hearing, Your Honor, I would say. When you sign a minute order and there's nothing we can find in the record, and yet we looked, that there was a hearing noted on the record in the district court, that it was just the judge signing off. Another problem was we couldn't find an SRDC report, which makes any hearing illegal anyway under Tillman. So how is he supposed to know? In fact, the district court, as we pointed out, never even told him he had a right to appeal. Judge Clark talked about, well, we're going to bring you back, or we're going to have an SRDC report done, and then we're going to decide. He talks in the sentencing about an appeal not once. So how's my client supposed to know? So I would submit to you, when he says to his attorney in the holding cell, after the sentencing, I want to appeal, that's it. What more do we really even have to talk about? The state says that happened.
Along those lines, I'm going to guess that your
Yeah.
position is not only that there's not substantial evidence to support the district court's findings, but that, in fact, the evidence is substantial and compelling to satisfy the Ortiz factors.
Yes.
So on my remedy question, your position would be we get an appeal.
Yes, that's the case. I don't think we have to go back.
Do we have to make that? I mean, how does that fact finding get made? I guess that's kind of what no court, I don't think, yet has found that the Ortiz factors have been satisfied. That finding has not been made.
Well, if you find that there's substantial evidence,
But then we would be making a fact finding, wouldn't we? And
No.
we don't do that.
the state has just conceded before you that hearing or that conversation in the holding cell took place.
Well,
But I'm sorry.
go ahead.
But our remand says, find out whether his testimony is credible, i.e., the point you're making, whether he told his attorney to appeal, and here's the part you're not addressing, and whether Smith would have appealed if his attorney had not failed to perform.
Right.
So you're just addressing the first point, I believe, but if I'm mistaken, correct me.
Okay. If I say to my attorney, hey, I want to appeal, I think that covers both. I am telling him, and obviously I want to appeal. If I'm instructing maybe I'm missing it, Your Honor, because if I'm telling my attorney, appeal my case, I think that satisfies both factors.
So these are redundant phrases in our remand.
Or in Ortiz originally.
Well,
They're pretty similar, aren't they?
they're pretty similar. If I say appeal my case, what more do I have to say to meet both of those? I've told my attorney, and I want to appeal.
The state is saying, in essence, it seems to me, logically, that the third also includes this concept that if you have subsequent conduct after expressing a desire for your attorney to take an appeal that belies your intention, that should count. That's in essence her argument.
Well,
And that's the only way I can differentiate 1 and 3 in Ortiz.
okay.
And,
Well,
and here, let me add
Yes,
to
sir.
that if I may, just to try to clarify. We also said in this case on remand, a bare assertion by the petitioner that she made a request for counsel to file appeal is not by itself sufficient to support a grant of relief if evidence that the fact finder finds to be more credible indicated the contrary proposition.
And what evidence did the fact finder find more credible here? None that I can see.
My understanding from his journal entry was he talked about, you're telling me your attorney said that you're not going to do any prison time for these crimes. And the judge said, I find that incredible that Mr. Opperman would have told you that. You also made inconsistent statements, among other things, about what you told law enforcement, that you're the one who pulled you told your brother that you're the one who pulled the trigger. And now in your motion, you're saying, I had nothing to do with this other than going out in the country with my acquaintances and the delivery driver. Those are just some of the things I understood from the journal entry that the court was saying, I'm just not finding Mr. Smith credible.
Well,
So he may have said, I want to appeal, but he did nothing after that to suggest that he was going to proceed with an appeal.
Well, I disagree. When I have my grandmother and my mother, who didn't testify, but if I have my grandmother call my attorney 5 to 10 times, as the undisputed testimony was, what is she calling him for?
The problem is that testimony was disbelieved by the district court. In other words, we just have a raw credibility determination here. And I guess we can go back and look. I don't think the state made a stipulation the way you described it, as they don't contest the fact. What I understood is the state says, yes, that was the testimony. The problem is we have a journal entry from the district court that says, I don't believe that testimony.
I thought the concession here today was that it happened. I'm sorry, that's at least as I heard it.
As I heard it, it was there's no substantial competent evidence to dispute that he asked the lawyer in the holding
Right.
cell to take an appeal.
Well, that's, I think,
But
satisfies.
if the judge doesn't believe the testimony, then there's no evidence at all.
So we're getting to a point then, it's not just an attorney saying, well, he didn't ask me to appeal. But we're getting to the point then where my client can testify, his grandmother can testify, and we're going to disbelieve him. Why? Because when he was 16, he said something different to the police than he later said. Is that how we judge whether someone can have an appeal or not? The district court also said, well, he had the sophistication to plan this attack on the pizza delivery driver. That's false. As we put in, there was a co-defendant, it was an adult, Laughlin, who actually was the prime mover, who called the pizza delivery guy, etc. So, I mean, we have a lot of things that are, I think, sort of skirting the honesty. And when we go to rap music and tattoos, and that he just wanted to live a tough life in prison, you know, I've met a lot of tough guys practicing law for 40 years. I don't know any of them that say, yeah, give me 2 life sentences and 10 years on top of that. But
We've had a very robust discussion about all of this, and so for obvious reasons, there are compelling. You made some compelling points. This line of questioning started though with me asking you to say, even if we agree with you that the credibility determination below is not supported by evidence, you're asking us to make the opposite credibility determination, and that's where I'm stuck. How does this court make a fact finding that says this testimony is true, and therefore the Ortiz factors have been met?
I don't think you have to make a fact finding that the testimony is true. You have to say there was not substantial evidence that to the contrary. The court cannot base its rulings on rap music and suppositions, and that my client, again,
Even if that's right, that doesn't mean that your client testified truthfully. That's where I'm getting hung up.
Well,
I mean,
and I would submit, I mean, the state's big problem here, I think, is would he have appealed? A person with double life sentences at 16 years old, why would he not appeal? I mean, that should be the default position, unless we have something differently. I think that itself is persuasive. And Your Honor,
But we've said that's the defendant's burden, have we not? And that's why we've gotten into this issue of negative finding possibly applying here.
right. And Your Honor, that's why I put on the evidence that my client, again, was 16, had ADHD, had repeated the 6th grade. I mean, to show you when the state is calling, well, he didn't do anything, we're not talking about me or a PhD in jail knowing what they can do. We're talking about this individual. And again, when the court says something like my client is cold, yeah, he's been in prison since he was 16 years old for the last 26 years, or 23 years. I mean, that makes people cold. Does it make them that you just can't believe them then? I mean, you could have a district court structure, well, I don't like that he's got tattoos, and I don't like that he doesn't have a happy demeanor here after being in prison for 26 years. He's toughened up. But that doesn't make him, the court can then say, well, that makes him incredible. I mean, because that gets into the basis, he's not like me, so I'm not going to believe him.
There was reference made earlier to the court's request for information about tattoos, music, etc., that somebody was claiming perhaps the defendant had listened to, or he had tattoos and brands on his body. That, I believe, was a statement made during a hearing by the judge. Is that right?
Yes.
And it does not, however, find its way into the judge's journal entry. Is that right?
I think that's correct.
So what, if anything, can we determine from that omission? Does that necessarily mean the judge said, I should not have considered that, so I'm not going to put it in my findings, or can we consider it?
The judge actually, on his own, this is not something from the state, sought that information.
I understand, but if it's not in the journal entry, can we say anything one way or the other about why it's not there?
I think if the judge is making, it's one thing if it's said to the judge, if the state had put it on and the judge said, all right, whatever. But he is making efforts to find this out and saying things about it, I think you have to say that he considered it. Along with, if you look at number 23, he's contradicting this court's ruling by saying that the delay itself, the time, the defendant waited all the years, did absolutely nothing. That is a separate and self-sufficient basis for this court to conclude the testimony of Mr. Smith is not credible. Well, this court said in the original Smith hearing from 2016, the length of time is not dispositive, but he's saying it is. I mean, the judge's decision is rife with issues like this, that he's turning things that are not the record into making decisions about whether my client has credibility and whether his grandmother has credibility, I guess.
Counsel, I see you're out of time.
Yes.
Do you have any further questions? Would you like 30 seconds to wrap up, or do you think you've made your points?
I think so, Your Honor. Thank you.
Thank you, counsel. I thank both of you for your arguments this morning. Court will take this matter under advisement. The court